On behalf of the Chief Justice and the organizing committee, and by extension, the legal fraternity, as tradition demands, I will now call on the representative of Imam Ratib of Banjul, Imam Muntaha Fai, to lead us in Muslim prayers.
الله الرحمن الرحيم الحمد لله رب العالمين الرحمن الرحيم ملك يوم الدين إياك نعبد وإياك نستعين اهدنا الصراط المستقيم صراط الذين أنعمت عليهم غير المغضوب عليهم ولا الضالين آمين.
May I now call on the representative of Christian Council, Reverend John Henry Fuller, to lead us in Christian prayers.
In the name of the Father, and of the Son, and of the Holy Spirit. Almighty God, we thank you this morning as Gambia We thank you for the peace that you have given us, Lord. We thank you for love. We thank you for the life of the President, the life of the Vice President, the ministers, the cabinets, heads of institutions. We give you all the glory, we give you all the praise. It is you that ordained this day. It is you that blessed this day. In the name of the Father, and of the Son, and of the Holy Spirit.
The fourth speaker, the President of the Gambia Bar Association. I will now call on Mrs. Mendy to come and deliver a statement. Council, you are welcome.
Excellency, the President of the Republic of the Gambia, Adama Barrow, Your Excellency, the Vice President and Minister for Women Affairs, the second most senior member of the Bar, Ousseynou Dabo, the first Gambian female lawyer, Madam Mariam Dentin, the Honorable Chief Justice Hassan B. Jallow, the Honorable Justices of the Superior Courts, the Honorable Attorney General and Minister of Justice Abubakar Tambadou, the Honorable Solicitor General and Legal Secretary Cherno Marena, the Chairman of the Qadi Appeals Panel, the Diplomatic Corps, your worships, all protocols here present, ladies and gentlemen. On this special occasion, I wish first of all to express our thanks to the Honorable Chief Justice for the pluck of resuming this important and noble tradition of the legal profession in marking the beginning of a new legal year, and for granting us the privilege to speak at this gathering on behalf of the Gambia Bar Association. However, I hasten to add that this legal year is not the old-age traditional legal year that the young ones at the bar and those of us not so young long for. The old tradition of going to the mosque on Friday and thereafter having a church service on Sunday, followed by a procession down the Independence Drive to the Law Court Complex, marks the beginning of a new legal year. We urge your Lordship, the Chief Justice, to restore this lovely tradition, which not only signifies that the Gambia is a secular state, but reinforces the unity of the Gambian people, irrespective of race, religion, tribe, and color. We also look forward to the Attorney General and leader of the bar hosting the usual legal year reception. This ceremony of the opening of the legal year does not only afford us an opportunity to review the situation of our judiciary and judicial system during the past years, but also to chart the way forward for this year, for the legal profession and the administration of justice in the country. The paramount quest of the Bar Association has been, and will always be, for the Constitution and its provisions in regard to the rights and freedom of the citizen to be upheld and be regarded by all authority as sacrosanct, for the rule of law to be observed by all, and the independence of the judiciary respected. In our opinion, the independence of the judiciary is an issue which is so important and critical to our progress as a nation that it requires to be given constant attention. The judiciary in a constitutional state is normally considered to be an aspect of the division of power, but it should also be seen in its relation to the structure of the legal profession. And in a democracy, both the spirit and the tradition that respect judicial independence must be cultivated and guaranteed. Issues that cannot be resolved by the other arms of government have a tendency to end up in the courts for determination, especially matters which concern provisions in the Constitution and the law. Martin Luther King, in one of his speeches, had this to say: "Judicial decrees may not change the heart, but they can restrain the heartless," unquote. Thus, in this regard, there should be insistence on obstacles to the ready dismissal of judges and prohibition of the vesting of judicial functions other than in duly constituted courts of law. Also, even though the remuneration of judges is charged directly on the Consolidated Revenue Fund, it is perhaps now opportune, in furtherance of the independence of the judiciary, for its independence to be extended to its financial operations as well. The judiciary should be ready to and poised to undertake the onerous responsibilities and duties that will emanate from the ongoing legal processes with regard to wanton abuse of the law and human rights of many citizens. This will require the availability of sufficient resources for ensuring the prompt and fair dispensation of justice. The courts must be credible and be seen to be apolitical. This proposition for the financial independence of the judiciary is vital in that an independent judiciary is as valuable to government as it is to the people as a whole. In this regard, the cost of litigation must not be made exorbitant for the litigant. Otherwise, we run the risk of denying them justice. It should, however, be emphasized that this notion of the independence of the judiciary also encompasses the independence of the bar as a professional organization, as well as the personal independence of its members, as the relationship between the bench and the bar is symbiotic. And that is why the Gambia Bar Association was very much involved in identifying some of the Gambian judges for appointment to the bench. A strong bar ensures a strong bench, because our judges, having been barristers prior to becoming judges, expect the bar's independence to ensure that legal arguments are presented with a clear degree of probity and vigor. Thus, the judgments of any court are indeed the collaborative efforts of the bar and the bench in order to arrive at a definitive decision as to the legal principles that relate to the facts of a case. The Gambia Bar Association as an institution assumes its inalienable right of occasionally making public statements about current legal issues of public concern so as to promptly nip in the bud any likely corrosive effects on public trust in the judiciary or the legal profession. The Bar Association has therefore to remain strong and must continue to serve the judiciary in particular and the public in general faithfully. As an instrument within the judicial system, the association will step up its contribution towards the country's growth and development that will engender peace and national unity. This is a time for reconciliation and healing in the nation. Is it not an affront that an edifice that was built from the labor of our farming community was taken over and converted by the NIA into a torture chamber, flanked by our Ministry of Justice and facing the courts of justice, whose very purpose is to defend the law and the rights of the individual enshrined in the Constitution? The way forward demands that all Gambians, both young and old, should engage in activities that bring about progress, peace, and stability in the nation, with a spirit of reconciliation, bolstered by a democratic culture, and founded on strict observance of the rule of law and justice for all. In this regard, the Bar Association will be launching its law clinic on the 6th of February 2019, to which this opportunity is being seized to invite all new members of the association to participate. Much as the work ahead of us may seem great and demanding, I want to believe that it will not be beyond our ken and collective efforts as a nation, endowed with a lot of blessings. Let us therefore strive to live up to the mantra, never again. In the name of the Gambia Bar Association, I pray that God will grant us a successful legal year. I thank you all.
Thank you, Madam President. Financial independence of judiciary is paramount. A strong bar ensures strong bench. Bar is here to serve both the judiciary and the public. It's our fervent hope that the government will hand over NSS complex to the judiciary. The bar has spoken. Thank you, Madam President. It is now my pleasure and honor to invite Attorney General and Honorable Minister of Justice, Mr. Abubakar Tamberi, to make a statement.
Excellency Adama Barrow, President of the Republic of the Gambia, Your Excellency, the Vice President, Honorable Speaker of the National Assembly, my Lord, the Chief Justice, Honorable members of the National Assembly here present, my Lords and Lady Justices of the Superior Court, allow me to stand on existing protocols. Your Excellency, distinguished guests, 2 years ago, we set out to restore public confidence in our administration of justice system, which was perhaps at its lowest ebb, following 2 decades of calculated interference in our judiciary and a systematic dismantling of the machinery of justice by the previous administration. Today, we are proud to say that we have in large measure achieved this objective, even though we also recognize that there is still room for improvement. Over the past 2 years, and in spite of the enormous human and material resource challenges, we have registered some modest progress in governance, and particularly in our efforts to rebuild a strong, indigenized, and independent judiciary. In the process, we have also empowered women by appointing them to decision-making positions. This is reflected in the judicial appointments made following the installation of this new government. Out of 12 new judicial appointments to the superior courts, 5 of the judges are women, including the first female Gambian justice of the Supreme Court, Justice Mam Yasin Si. 4 out of the 7 justices of appeal are now women, including the president of the court, Justice Awaba. And for the first time in the history of the Gambia, we now have a fully constituted, exclusively Gambian permanent Supreme Court bench. We have also established within my ministry a sexual and gender-based violence unit that will now be responsible for handling all criminal cases of sexual violence and abuse. Members of the unit will receive specialized training in the investigation and prosecution of sexual violent crimes against women and children. Moreover, we have reinstituted professional discipline at the ministry so that all legal matters are now handled in accordance with the law and the dictates of the legal profession. Other modest achievements include the establishment of the Janneh Commission of Inquiry to investigate the financial delinquency of the former president and to expose and fight corruption. The establishment of the Constitutional Review Commission to draft a new constitution based on ongoing consultations with Gambians at home and abroad. The establishment of the ongoing TRRC to investigate past human rights violations and abuses, restore the rights and dignity of victims by giving them a voice and through appropriate reparations, and to recommend ways of preventing recurrence. And the establishment of the National Human Rights Commission in full compliance with the Paris Principles of Autonomy and Independence, and whose members will be sworn in soon by His Excellency, the President. Arbitrary arrests have significantly gone down, and detention without trial no longer obtains. Those in detention now readily have access to their counsel. Your Excellency, distinguished guests, in the course of this year 2019, we have identified key priority areas of focus and have already initiated steps to get the activities underway. We will be conducting a comprehensive review of the Criminal Code and the Criminal Procedure Code as part of the sanitization of our criminal justice system. This review exercise will commence soon, as the process for the recruitment of local consultants have already been initiated. I take this opportunity to extend gratitude to the Korean International Cooperation Agency, KOICA, who are graciously funding this review exercise through the United Nations Office on Drugs and Crimes, and I also thank the latter for their partnership in this process. Also, in collaboration with Article 19 and the Ministry of Information and Communication Infrastructure, we have commenced the review of all media laws to ensure consistency with our constitutional obligations and to facilitate the exercise of the right to freedom of expression. In fact, this review exercise should have been completed in large part by the end of last year, but due to a confluence of factors, we could not achieve our target. We hope to make substantial progress in the course of this year. Notwithstanding the absence of appropriate legislation for the time being, the government has demonstrated good faith in this regard by allowing the proliferation of private newspapers and radio stations that encourage the free flow of ideas among the citizenry, without fear or repercussions, I will add. Indeed, the Gambia has significantly improved its ranking in the 2018 Annual Press Freedom Index, scoring 122nd out of 180 countries, compared to 145th in 2016 and 143rd in 2017. We are also at the final stages of reviewing an anti-corruption legislation to replace the Anti-Corruption Act of 2012, which was heavily watered down by the previous administration. While there is genuine concern about corruption in the country, the 2018 Corruption Perception Index by Transparency International has recognized the Gambia's improved score over last year's based on political commitment, laws, and institutions. As a result of ongoing efforts at tackling corruption, there has been a marked improvement in financial governance, with rigorous enforcement of the financial regulations by government departments. Notwithstanding, the perception of widespread corruption must always be of concern, as it does little to encourage investment in the local economy, among other undesirable consequences. But more importantly, corruption kills. Every dollar taken from state coffers is food taken away from the mouths of hungry children, or medicine taken away from the sick, dying of preventable or curable diseases. All the more reason we should expose it whenever it occurs and continue to fight it in all its forms so that it does not take root or become pervasive. We will also engage in reform of the electoral process in consultation with key government stakeholders, the Independent Electoral Commission, and all registered political parties in the country. We of course recognize that the ongoing constitutional review process will likely address fundamental aspects of the electoral process, and we will keep an eye on that parallel process as we embark on ours. Far-reaching reforms of our prison system has already commenced with internal review of the Prisons Act led by the Ministry of Interior. However, this is just one aspect of our reform objective. We want to overhaul our entire prison system and transform our prisons so that they do not only serve as a decent place of detention for our fellow humans, but also for the rehabilitation of prisoners in preparation for their reintegration into society at the end of their prison terms. Your Excellency, distinguished guests, ultimately, the extent of our success will largely depend upon the extent of our commitment to strengthen the judicial and legal sectors by devoting adequate resources to the sector. In this regard, allow me to extend sincere gratitude to you, Your Excellency, and to your government for recognizing the indispensable role of an independent judiciary in a democratic state, and for strengthening it by increasing its much-needed resources in the 2019 national budget. We are grateful for this show of support to our judiciary. Allow me to add, however, that this improvement in resource allocation should only be regarded as the beginning and not the end of this crucial support. For if we want to attract quality Gambian personnel to the bench, we must make the conditions of service commensurate with their standing in society. Anything less will seriously undermine our efforts towards quality Gambianization of our judiciary. Meanwhile, I take this opportunity to also thank His Lordship, the Chief Justice, and all our judges for accepting to serve our country under such challenging circumstances. Yours is the ultimate mark of patriotism, and I assure you that we will not relent until we make our judiciary the envy of our sub-region. And finally, to our friends on social media, I call on you to play a more responsible role in our rebuilding process. It is an honor and privilege to serve one's country, and democracy gives you no right to insult or abuse those who do or their parents. It is unacceptable even by the standards of our own cultural norms and values. We welcome criticism because it makes us provide better service to you, and it is unavoidable in public office. But criticism can and should be constructive and healthy. If we do not stop the unjustified personal and disparaging attacks on those holding public office, we risk depriving our country of its fullest potential. I say this because I have had instances when I have personally approached some competent, decent, and honest individuals for work, and after consulting with their families, they turned down the offers simply because they felt that working in public office in the Gambia these days exposes them and their family members to disrespect and unnecessary ridicule on social media. I am sure, actually, that I too will receive insults and abuses for even saying this here today. Your Excellency, distinguished guests, the best thing that has happened to us as a country is the freedom that we all enjoy today. There is simply no price tag to this freedom. Therefore, let me make this clear, that this government, under the leadership of His Excellency President Barrow, is as committed to rebuilding a new and democratic Gambia today as it was on 1st December 2016. There is no intention whatsoever to re-establish dictatorship in this country, and that those who may have concerns about emerging signs are simply confusing innocent mistakes with sinister intentions. On the other hand, those who are constantly looking for mistakes by this government will always find faults, simply because every government has its own challenges, and also because of the unique circumstances in which we find ourselves as a country in transition. We inherited a system of governance where state institutions, from the presidency to the lowest levels, were systematically dismantled over a 2-decade period, and where we found no culture or practice of state protocol in consonance with democratic practice. In many instances, we have had to rely on conventional wisdom. Given these circumstances, there are bound to be mistakes. But when mistakes occur, point them out to us in a constructive manner and make suggestions on how to avoid them in future. Do not just sit back and moan and groan and blame. You can surely do much better than that. And lest we forget, those countries that currently do better than us in governance have had their own fair shares of trials and tribulations for centuries before getting to their current levels of development and evolution. Ours will surely come too, but only with time and maturity. The new Gambia is therefore not about winners and losers. We either succeed together or we fail together, because as a nation we are bound together by a common destiny. But failure is not an option, and that is why we must persist and we must persevere, especially in the face of adversity. This is the burden of responsibility that we carry as pioneers of this change. So I call upon everyone, especially the political class, civil society organizations, youth organizations, women's groups, and the media fraternity to refocus and rededicate ourselves to the noble cause of the common good. People have died for this cause, and we must never lose sight of that reality in our dealings with each other. For when we stand together shoulder to shoulder, it is the Gambia that wins. I thank you all for your kind attention and wish you a fruitful year ahead.
It is now my pleasure and real honor to call on His Lordship, the Honorable Chief Justice of the Gambia, Justice Hassan B. Jallow, CRG, to address this occasion. My Lord, You are welcome.
Republic of the Gambia, Mr. Adama Barrow, Your Excellency the Vice President, Honorable Speaker of the National Assembly, Honorable Judges of the Superior Courts of the Gambia, Your Worships, Magistrates, Cadis, Honorable Attorney General and Minister of Justice, Honorable Ministers, Secretary General of the Civil Service Chiefs, Sefolu, and Presidents and members of the district tribunals, Justices of the Peace, Commissioners of Oaths, Notaries Public, President and members of the Bar, the Director General of the Gambia Law School, our distinguished guest here today, the Secretary General of the Commonwealth Magistrates and Judges Association, venerable religious leaders, members of the Diplomatic Corps, distinguished guests, ladies and gentlemen. I am very pleased on behalf of the judiciary and the rest of the legal profession to welcome you all here today to this ceremony marking the formal opening of the 2019 legal year. We are indeed greatly honored by the presence of Your Excellency, the President of the Republic, as the head of the executive, indeed the head of the country, at this auspicious occasion on the premises of the Judicature, which is the third arm of the state. First celebrated on 21st November 1982 at the McCarthy Square, in the presence of His Excellency, the then President of the Republic, Alhaji Sir Dawda Kairaba Jawara, this occasion in this form has been consistently marked annually only from 1982 up to 1994. Since then, it has been intermittently organized until today. And so, as we do so, we fervently hope that Your Excellency's presence here today will mark the end of that era of indifference to a great occasion and institution, and the beginning, indeed, of a new era in which, as required by Section 120 of the Constitution, the government and all departments and agencies of the government shall accord such assistance to the courts as the courts may reasonably require to protect their independence, their dignity, and their effectiveness. The legal year celebration is not only a matter of pomp and ceremony. It is an occasion for stock-taking and for reflection on the achievements of and the challenges facing the judicature and the machinery of justice to enable us to identify appropriate strategies to meet those challenges. Hence, in addition to today's ceremony, this year's program will feature the call to the bar tomorrow of some 58 students of the Gambia Law School, both Gambian and foreign students, who have successfully completed the vocational stage of their studies. It will include a training program on Tuesday for the Justices of the Peace. It will be followed on the Wednesday by a retreat of the judges designed to formulate the 5-year strategic plan, development plan for the judiciary. There will be other activities organized by the members of the Bar Association as well, including, as the President has just disclosed, providing legal services to the community. Permit me to, at the outset, to record our appreciation to the Legal Year Organizing Committee under the leadership of the Honorable Justice Sala Wada, and including other staff of the judiciary, the Attorney General's office, and members of the Bar, for putting together an excellent program for all of us today. As we take stock of the past 2 years, beginning January 2017, with the change in administration in all the organs of state, we wish to emphasize that efforts at reconstruction of the judiciary have been guided by the 3 key aspects of that institution's mission: judicial independence, judicial impartiality, and judicial efficiency. There has, to this end, been some significant progress in the strengthening of the capacity of the judiciary in terms of human resources, in terms of infrastructure, equipment, and training, in order to assist it more effectively discharge its core mandate of adjudication. It will be recalled that 2017 started off without a Supreme Court for the Gambia, that for 2 years prior to that, indeed, the court had not sat, and at the best of times before that, when it sat, it held 2 sessions per annum. Since then, the Supreme Court has been fully reconstituted with 4 Gambian justices in the persons of the Honorable Justice Semega Jane, Justice Sok, Justice Suleiman Jallo, and Justice Mamiasin C, joining me for the first time to constitute a full Gambian bench of the court. Our brothers Yahya and Justice Brown Mark of Sierra Leone continue to sit with us on the sessional occasions in order to complement the local judges. We are indeed committed to sitting more frequently, and from the beginning of this year, the court plans to hold a session every 3rd month of the year. The Court of Appeal, too, has seen a full Gambianization of its complement of 7 judges, with the Honorable Justice Mbai, Justice Njai, Justice Salawada, Justice Roche, Justice Mahoney, and Justice Sila Kamara, under the presidency of the Honorable Justice Awaba. While the subordinate courts, that is the Magistrates Court and the Cadi's courts, enjoy a full complement of judicial officers, we continue to face serious challenges in filling the vacancies for positions of judges in the High Court. That court, the High Court, it may be recalled, has both original and appellate jurisdiction. The High Court is the first instance court for the most serious criminal cases, such as murder, rape, land disputes involving questions of title, economic crimes, etc. The High Court has exclusive original jurisdiction in the very, very important area of enforcing fundamental human rights and freedoms that are guaranteed by the Constitution. It is also the court which hears all appeals from the subordinate courts, that is the Magistrates Court. Thus, the High Court is a very important bridge between the subordinate courts and the other superior courts, such as the Court of Appeal and the Supreme Court. Its efficient functioning is thus crucial for the proper administration of justice. Despite the advances made since 2017 to encourage Gambians to the High Court bench, with the appointment of Justice Zainab Jawara Alami, Justice Sena Buwada Sise, Justice Ibrahima Jaite, and the late Justice Buba Jao of blessed memory, joining the Honorable Justice Amina Saho Sise, as well as the generous secondment by the federal government of Nigeria in 2018 of Justice Kweju Bola, Justice Bakri, and Justice Musale on technical assistance. Despite all these advances, the High Court bench remains seriously understaffed and the judges seriously overloaded, with each of them managing at least 120 cases at any time. And the cases continue to come on a daily basis. The high vacancy rate, this high vacancy rate of 6 of the positions, 6 out of the 14 positions in the High Court being vacant is quite undesirable. It is not good for efficiency, and if it's not checked, it will impact very soon and seriously on the progress of cases, causing considerable delays in the hearing and determination of cases. Gambians themselves must take responsibility for providing justice to their compatriots. Whilst we are indeed extremely grateful to the Federal Republic of Nigeria for the support that they have given to this judiciary for several decades by seconding good staff, good judges to this country, and whilst we are appreciative also of the very valuable service rendered by these judges, it is time now for all members of the Gambian Bar who are in all respects qualified to take up positions on the bench to make their services available for the common good of the nation. In order to further facilitate dealing with the vacancies of the judiciary, the judiciary will also be submitting proposals to the government to review and amend some of the constitutional provisions relating to the appointment of High Court judges in order to facilitate the elevation of suitably qualified members of the subordinate courts. The program for 2019 has already been kick-started in January this year with training in case management, in judgment writing, in training of coroners for carrying out inquests for all magistrates, the training of trainers, and a workshop aimed at developing sentencing guidelines which will be used by the courts. We are indeed grateful that the Judicial College of the United Kingdom and the Commonwealth Judicial Magistrates and Judges Association has undertaken this particular training in January of this year. We expect that such training will be reflected in better staff performance and the improved efficiency of case management. And I would like to record our appreciation to the European Union, to the Judicial College of the United Kingdom, the CMJA, the National Judicial College of the Federal Republic of Nigeria, which provided induction training for our new judges in Abuja, the Kabas Charity Foundation, the Institute for Human Rights and Development, the National Environmental Agency, UNICEF, Prison Fellowship International, and the UNDP for their assistance in the delivery of various components of the training program in 2017 and 2018. In order to enhance staff conduct and performance within the judiciary, I have also recently revived and reconstituted the Judiciary Ethics Committee, comprising Honorable Justice Raymond Sok as chairman, assisted by Honorable Justice Salah Wada and Honorable Justice Hadi Roche. The committee is mandated to monitor and investigate the conduct of judges, magistrates, and cadis in order to ensure their compliance with the Code of Conduct for Judicial Officers. Provision in the 2019 budget of the judiciary for the establishment of a human resources and monitoring unit is designed to, and we expect it will improve staff management and performance. During the period under review, we unfortunately lost a number of our valuable staff, as mentioned earlier. Honorable Justice Buba Jao, Kadi Ibrahim Jame, Assistant Registrar Modu Jaju, our interpreter Aisatu Jamanka Ndao, District Tribunal Scribe Sheikh Hydra, our cleaners Esa Sise, Rohi Sanyang, and Amisanyang. We extend our condolences to the bereaved families and pray for the Almighty to grant eternal peace to the departed and to continue to guide and protect those that they have left behind. Your Excellency, Mr. President, one of the greatest challenges facing the judiciary currently is the acute shortage of appropriate courtroom and office space. Space requirements have not kept up with the workload and with the expansion of the judiciary through the creation of new and specialized courts and the recruitment of judges, magistrates, and other staff. The situation in the provinces following rehabilitation in the past year of the Soma Kadis Court and rehabilitation of our facilities in Mansa Konko and Basse has improved the situation in the provinces to the point where, with the recruitment of new judges, the high courts in Mansa Konko and Basse can become fully operational. The Greater Banjul area, however, suffers from acute shortage of courtrooms and office space, with several magistrates sharing the same, that is sharing courtrooms and sharing office space, queuing for courtrooms, and thus being unable to operate optimally. The Court of Appeal, which sits daily, has no courtroom of its own, but shares with the Supreme Court the totally unsuitable facilities of the latter. We are pleased that the government has, in the 2019 budget, provided the sum of $25 million for the construction of a new court complex in the Combos to cater for additional space for the High Court, the magistrates, and the Qadis. The design of this complex has been concluded, and we do expect construction to commence in the course of the current legal year. The sum of $1 million has also been budgeted for preliminary work on the establishment in the Comoros of a complex for a new specialized commercial and land disputes court in order to expedite adjudication in these very critical areas. The sum of $2.5 million is also budgeted for preliminary work on improving IT infrastructure within the judiciary. We expect delivery shortly of 2 generators to be installed at the Law Courts complex here in Banjul and at Kanifing from resources provided under the 2018 budget. A further allocation has been provided in the current 2019 budget for installation of additional generators for the other courts in the Comoros. We are indeed grateful to Your Excellency's government for these very important allocations and for the measures that are being taken since last year to alleviate the transport challenges facing judicial officers and to improve their conditions of service. Your Excellency and the distinguished guests, turning away now to the core adjudicatory function of the court, I am pleased to report some progress in performance, despite the numerous challenges, and if I may add, despite the numerous complaints. There has been a good performance by the judiciary in the discharge of its core function of disposing of cases. During the period 2017-2018. During that period, for instance, 2017 and 2018, out of the 4,458 cases which came before the Magistrates' Court countrywide, the magistrates had and determined 3,196 of them. They disposed of them. Now, of the 1,719 cases which came before the High Court during the same period, the High Court judges, despite the low strength, the low numbers of judges in that court, the High Court judges dealt with and disposed of 883 of them. That's just over 50% of the cases, leaving a balance of 836 cases to be carried forward. The Qadi Appeals Panel also did well. They had 58 appeals filed before them during those 2 years. Out of the 58 appeals, they were able to conclude 53 of them, leaving only a balance of 5 pending cases which carried forward into 2019. In 2018, the Qadi Appeals Panel also had 51 appeals, and they disposed of 30 of them, leaving 21, which were then carried forward. The subordinate Qadi's courts countrywide in 2017 had a total case docket of 1,141 cases, and they disposed of 613 of them. In 2018, the same Qadi courts, subordinate Qadi courts countrywide, they had a caseload of 1,304 cases, and they were able to dispose of 678 to hear them and determine them to a conclusion. Thus, the entire Qadi court system in the country in 2017 and 2018 had a total caseload of 2,554 cases, and they had and disposed of 1,287 of them by the end of 2018. The Gambia Court of Appeal, after delivery of 29 rulings and 30 judgments by the end of 2018, had only 67 cases left on its docket, carrying forward into 2019. And with the increase in the number of Court of Appeal judges, the court is now able to operate in several panels simultaneously, thereby expediting the disposal of its cases. Now we come to the Supreme Court. The Supreme Court, which is the final court in this country, in the period 2017 and 2018, has had a docket of 83 cases filed before it. And it was able to dispose of 50 of them during that period, leaving a balance of only 33 cases carrying forward into 2019. And altogether, all these statistics point to an astoundingly heavy total national caseload of 7,630 cases in all the courts for 2017 and 2018. 7,613 cases in the courts in this country in 2017-2018. And this is excluding the cases which are before the district tribunals of the country, the 47 district tribunals of the country. It is a heavy caseload, and if I may add, an equally commendable achievement by the judiciary, by the courts, in hearing and concluding 5,538 of the cases. In other words, out of 7,600 cases, the courts were able during this period to dispose of 5,538. I would like to particularly commend the caddies, the magistrates, and the judges of the High Court for this exemplary, excellent performance during the period. Despite the fact, as I said, that the High Court has been operating well below capacity. Out of a budgeted total number of 14 posts for judges, only 8 have been filled so far, and there remain 6 yet to be filled. I would also like to commend and congratulate the members of the bar, the law officers, the police, and the support staff, all of whom contributed to these achievements. Your Excellency, Mr. President, distinguished guests, the case statistics, impressive as they are, nonetheless also disclose a disturbing trend that we are becoming extremely litigious. We are becoming extremely litigious. There are too many cases in the courts. The current caseload of the courts is too heavy for the system of justice to bear. Resort to the courts is, of course, undoubtedly a mark of confidence of litigants in the court system. They are confident that when they come before the courts, they will receive independent and impartial justice. But litigation should, however, be a last resort. When out-of-court settlement has failed, when it has been explored and it has failed, that is when resort to court should take place. Litigation should not be a forced resort to the courts. An overburdened judicial system will only lead to further delays in the disposal of cases and sometimes to poor management of cases. All parties to a dispute, as well as their counsel, must therefore deploy all efforts at out-of-court settlement before instituting legal proceedings. I also call on all community leaders as well to promote and encourage the settlement of civil disputes out of court. The judiciary itself will play its part in this respect, with a review and a strengthening of the court-annexed alternative dispute resolution mechanism in order to ensure that in each case, in each civil case, that serious efforts have been made by the parties for resolution before a dispute is litigated in court. Your Excellency, Mr. President, the primary challenge for any judicial system lies in its independence and impartiality. You have, Mr. President, lived up to both your public and private assurances of non-interference in the judiciary and for respecting its independence. Those assurances are encouraging to judicial officers and users of the system at all levels, and judicial officers continue to live up to their own oaths to dispense justice fairly and impartially and without fear or favor. I am pleased also to report that there has been some progress towards the administrative and financial autonomy of the judiciary as envisaged by the Constitution. For the first time, the annual estimates of expenditure for the judiciary were, as required by Section 144 of the Constitution, submitted by the Chief Justice in respect of financial year 2019 to His Excellency the President of the Republic, who, pursuant to that provision, directed the Minister of Finance to lay the same before the National Assembly without any alteration. We are indeed extremely grateful to Your Excellency for this adherence to the constitutional requirement. Furthermore, in pursuit again of the constitutionally guaranteed autonomy of the judiciary, as from January 2019, the judiciary will become fully autonomous, indeed has become fully autonomous with regard to the appointment of its staff. It will be recalled that the Judicial Service Commission, pursuant to Section 138 of the Constitution, is mandated to recommend to the President the appointment of judges, and pursuant to Section 146 of the Constitution, to appoint magistrates and other specified officers of the court. Other staff not falling within these two categories will now be appointed in-house in accordance with a mechanism that I have established in accordance with Section 146, subsection 3 of the Constitution. These two measures, I believe, will assist the judiciary in the better management of its financial as well as its human resources. But challenges do nonetheless remain, which need to be addressed to complement the commitment, the dedication, and the hard work of the judicial officers in order to improve the machinery of the judiciary in its core function as well as in its other activities. The challenges faced by the judiciary ultimately impact on the speed and efficacy with which its core function of hearing and determining cases is discharged. We remain firmly committed to the avoidance of unnecessary delays and to expediting the hearing of cases, particularly the criminal cases, where very often the accused persons are in custody. This, however, requires the collaboration of several actors and several agencies. For instance, in the case of the criminal jurisdiction, it requires the collaboration of the police, the Attorney General's chambers, defense counsel, accused persons naturally, and of course the witnesses. I have directed all courts to give priority to the hearing and disposal of criminal cases, be they at the subordinate courts level, the magistrates, or at the level of the High Court. And I accordingly renew my call to all the actors and the agencies involved in the criminal justice process to deploy all efforts for speedy disposal of criminal matters. Your Excellency, Mr. President, the judiciary requires more courtrooms and office space for the optimal functioning of the courts. It requires a new Supreme Court. It requires a new Court of Appeal complex. It requires additional space for magistrates in the Greater Banjul area and more Cardiff courtrooms countrywide. A new court complex for the Commercial and Land Disputes Court. We need more judges for the High Court, preferably recruited locally, with improved conditions of service, with incentives to ensure that we can recruit and retain the appropriate people. We need to improve working methods and systems in the judiciary, moving away from the slow, inefficient manual systems to harnessing the benefits of modern technology for greater efficiency, particularly in the recording and transcription of court proceedings, and also in the storage and management of our documents and archives. We need better transport arrangements for judicial officers. In a small jurisdiction such as the Gambia, private transport for judicial officers is not a luxury. It is a necessity to ensure their security, but also very important to ensure that they are insulated from possibly compromising situations, which can impact on their independence or impartiality. So we need assistance there as well. We need to strengthen alternative dispute resolution systems in order to ensure that litigation is a last resort. We need to review outdated rules of procedure and practice which hinder speedy and fair disposal of cases. Our law reform and our law reporting institutions, while not falling directly under the judiciary, their performance impacts very much also on the judiciary and of the entire legal system. We need to strengthen the Law Reform Commission. We need to strengthen the Law Reporting Council, ensuring that they have adequate resources for them to be able to discharge their statutory responsibilities. All of these that I have mentioned, and perhaps more, need to be undertaken and accomplished in order to secure the strongest foundations for the rule of law in the Gambia. Attaining all of them may take some time. It will require considerable public investment in the judiciary. It will require the active involvement of the bench and of the bar, indeed of the entire legal profession, shouldering and discharging their respective responsibilities. 3 days from now, the judiciary will be convening to deliberate on the 5-year strategic plan, as I indicated, and we expect that from this retreat will emerge a roadmap to guide the state, to guide all relevant stakeholders, and to guide potential funders on the way towards improving the machinery of justice for the country. Your Excellency, much public investment has already been made by your government in the judiciary, and we are indeed extremely grateful and appreciative of that. Much more is required in the judiciary now than in the past, in consonance with the topmost priority given to good governance in the National Development Plan. There can be no good governance without the rule of law, and there can be no rule of law without an independent, impartial, and efficient judiciary able to administer and deliver justice, and to deliver it fairly and reasonably speedily. Effective justice is the cornerstone of the rule of law, and the rule of law is the foundation for peace and for progress. The rule of law, however, is not readily made. It has to be created with significant public investment and with the support of other stakeholders. We pray that due cognizance will continue to be taken of these considerations in the execution of the National Development Plan of the Gambia. It is now my great honor and pleasure to invite Your Excellency, Mr. President, to address the gathering and to declare open the 2019 legal year. I thank you for your attention.
Honorable Speaker of the National Assembly, Justices of the Superior Courts of the Gambia, Honorable Secretary General and Head of the Civil Service, Honorable Cabinet Ministers, Honorable Members of the National Assembly, the President of the Gambia Bar Association, and members of the Bar, members of the diplomatic community, magistrate cadis, distinguished members of all subordinate courts, ladies and gentlemen, all protocols respectfully observed. Good morning. It is indeed my delight and honor to appear before the members of the legal fraternity on this very auspicious occasion dedicated to the legal year. As this is my first time officially, this is my first official engagement with members of the legal profession since I assumed office just over 2 years ago. I want to seize this opportunity to pay tribute to the gallant men and women of the Gambia's legal profession for their principle and patriotic stance following the attempt to subvert the will of the sovereign people of the Gambia in 2016. You have left your mark in the history of the country by showing exceptional character and leadership against the dictatorship in the Gambia after 2016 elections. My presence and other members of the executive arm of government at this occasion is a testimony of my government's strong commitment to the rule of law, judicial independence, and the fundamental human rights of all citizens. Distinguished ladies and gentlemen, after assuming office, my government undertook a number of measures to stabilize the economy, restore public confidence, and strengthen democratic institutions. Accordingly, the 4 strategic priorities of the National Development Plan 2018-2021 is restoring good governance, respect for human rights, the rule of law, and empowering the citizens through decentralization and local governance. In this light, we have taken a number of strides in fulfillment of these development aspirations. After many years of judicial maladministration, we sought to sanitize the judicial administration and ensure judicial independence in the country with the appointment of our distinguished current Chief Justice. I have said it many times. I think this government, we have been very, very brave to appoint a human rights lawyer as Minister of Justice and a human rights lawyer as the Chief Justice of the Gambia. This was followed by the reconstitution of the Supreme Court after a 3-year break. In 2017, we Gambianized the judiciary with the appointment or reinstatement of 12 Superior Court judges. As opposed to the intolerable practice of sacking judicial officers without any just cause. As witnessed in the past, no judicial officer has been arbitrarily dismissed from office since I assumed office. On this auspicious occasion, I once again pledged my firm commitment not to interfere in the judicial administration of the country. To guarantee judicial independence, the 1997 Constitution of the Gambia provides for the financial autonomy of the judiciary by providing for the direct presentation of judiciary's budget to the National Assembly, rather than through the Minister of Finance. For the first time since 1997, Constitution came into force. This constitutional provision was given effect this year, 2019, after I gave approval to the request by the Honorable Chief Justice. My government is also committed to attracting the very best legal brains to our judiciary. It goes without saying that this can only be achieved by offering better conditions of service for judicial officials. Accordingly, effective January 2019, we have approved an improved payment package for judicial officials. In this regard, let me use this opportunity to express my heartfelt condolences to the entire legal fraternity and the family of the late Justice Buba Jao of the High Court of the Gambia on his demise in December 2018. May his soul rest in perfect peace. Ladies and gentlemen, in line with the commitment of my government to build a strong foundation for good governance and more effective checks and balances, we have instituted a Constitutional Review Commission exclusively comprising distinguished Gambians to draft a new constitution that will usher the Third Republic of the Gambia. As a country, we have to systematically deal with the past human rights abuses meted out to innocent Gambians over the last 2 decades of authoritarian rule. Thus, we have put in place a transitional justice mechanism that seeks to document the truth about the human rights abuses and make certain that we never again undergo such ugly episodes in our beloved country. The True Reconciliation and Reparation Commission, which has already commenced work, will provide an opportunity for both victims and perpetrators of human rights abuses to explain their stories in order to establish the truth, promote reconciliation, and ensure that justice is served in appropriate cases recommended by the Commission. As part of the efforts to change human rights architecture of this country, the National Assembly enacted the National Human Rights Commission Act in December 2017. A rigorous and competitive selection process was instituted thereafter to select the 5 commissioners for the first ever National Human Rights Commission for the Gambia. I am happy to announce that recently I endorsed the appointment of these 5 commissioners. Once the commissioners start effective operation, I expect that no Gambian in any part of the Gambia will suffer any human rights abuses without redress. It is equally expected that this commission will provide a reliable alternative for ordinary Gambians who have found the court system both expensive and cumbersome. The government has instituted a criminal justice and prison legislative reform project to repeal laws which were used as instruments of repression against Gambians. The goal for this decision is to attain a just society. The process involves a review and redrafting of the Criminal Code, the Criminal Procedure Code, and the Prison Act for the first time since attaining independence in 1965 in order to align them with international norms and best practices. My Lord, the Chief Justice, and members of the Gambia Bar, I appreciate the collective efforts to improve our judicial and legal system. However, much remains to be done to attain the collective aspiration of our people. The court cases still move at less than an ideal pace. Legal fees are still very high for the average citizen, and many Gambians still have to travel long distances to access court outside the Greater Banjul area. These challenges and many more will have to be overcome by the joint efforts of the executive, the judiciary, and the legal fraternity. Together, we can overcome them. To conclude, I congratulate all members of the legal profession on the achievements realized so far. It is now my honor to declare the legal year 2019 open, and I wish you a successful legal year. Thank you.
The President now is going to meet the staff of the Judiciary and Ministry of Justice